What if the government passed a law promising transparency and then simply refused to follow it? And what if a journalist, armed with legal standing and a law degree, decided to do something about it? That's exactly what's happening right now in a federal courthouse in Washington, D.C. An independent journalist and attorney has filed a lawsuit against the acting Attorney General of the United States, demanding that the Department of Justice actually comply with a law Congress passed requiring the release of the Epstein files. Not a request, not a petition, a lawsuit. And the implications stretch far beyond one journalist's access to documents. Let's talk about what's really going on here, because this case touches on press freedom, government accountability, the rule of law, and one of the most explosive criminal investigations in recent American history. To understand why this lawsuit matters, you need to understand the Jeffrey Epstein case and why it has refused to go away for years. Epstein was a wealthy financier who ran an international sex trafficking operation that victimized dozens of young women and girls over many years. He died in federal custody in August 2019 under circumstances that a significant portion of the American public and many legal experts found deeply suspicious. The official ruling was suicide, but questions about the security failures, the camera malfunctions, and the circumstances of his death have never been fully answered to the public's satisfaction. His longtime associate was convicted on multiple counts related to the trafficking operation and is currently serving a lengthy federal prison sentence. But from the very beginning, the public knew there was more to this story. Epstein didn't operate alone. He had a network. He had powerful associates. And the evidence gathered by federal investigators, the flight logs, the documents, the photographs, the witness statements, potentially implicated people at the highest levels of business, politics, and celebrity culture around the world. For years, victims' advocates, journalists, and members of the public demanded answers. Who else was involved? Who knew? Who was protected? Partial documents have trickled out through various court proceedings and FOIA requests, but the full picture, the complete federal investigative file, has remained hidden from public view. Then Congress acted. Legislators passed the Epstein Files Transparency Act, a law specifically designed to force the release of the federal government's complete files on the Epstein investigation. This wasn't a suggestion, it wasn't a recommendation, it was a law, signed legislation. The kind of thing the Department of Justice is legally obligated to follow. And then, nothing. The DOJ, under the current administration, simply didn't comply. The files weren't released in the way the law required. The transparency the law promised didn't materialize. And for journalists covering this story, that meant they couldn't do their jobs. That's where our journalist and attorney comes in. She had been covering the Epstein case extensively, building a following through independent journalism, digging into the facts and evidence surrounding Epstein, his convicted associate, and the network of powerful individuals who have come to be known informally as the Epstein elites. Her reporting depends on access to primary source documents, the actual files, not filtered summaries, not selective releases, not whatever the government decides you're allowed to know. When the DOJ failed to comply with the Transparency Act, she made a decision that not many journalists, even those with law degrees, would make. She sued. On April 27, 2026, Case 126 CV01417 was filed in federal court. The defendant is the acting Attorney General. The plaintiff is a journalist asserting that she cannot perform her constitutionally protected function as a member of the press because the executive branch is refusing to follow a law that Congress passed. Let's break down what the lawsuit actually argues, because the legal theory here is important and frankly fascinating. The complaint contains multiple counts. The first count essentially argues that the DOJ's failure to release the files as required by the Epstein Files Transparency Act is a straightforward violation of federal law. The argument is simple on its face. Congress passed a law. The DOJ isn't following it. That's illegal. A court should order them to comply. This type of claim, called a mandamus action, or an action to compel agency action, has been used throughout American legal history when federal agencies refuse to carry out duties that are clearly defined by statute. The journalist isn't asking the court to create a new right. She's asking the court to enforce an existing law. The second argument relates to her specific standing as a journalist. This is legally significant. To bring a lawsuit in federal court, you have to demonstrate that you have standing, meaning you have a concrete, particularized injury that the court can actually remedy. She argues that as an independent journalist covering the Epstein case, the DOJ's non-compliance with the Transparency Act directly injures her ability to report. She can't access the documents she needs to do her job. That's a real, tangible harm. And because the court could order the DOJ to release the files, the harm is redressable. Now, standing arguments are often where these kinds of cases get dismissed, so this is a critically important legal hurdle. But the journalist's dual background, as both a member of the press and a licensed attorney, actually strengthens her position in ways that a purely press-based claim might not. One of the most interesting elements of the lawsuit is her request for a special master. For those unfamiliar with the term, a special master is a neutral third-party official appointed by a court to handle specific tasks, often the review of sensitive documents. You might remember the term from other high-profile legal battles involving government documents and questions of privilege. In this case, the journalist is requesting that the court appoint a special master to oversee the review and release of the Epstein files. The idea is to create an independent, court-supervised process that prevents the DOJ from slow-walking the release, claiming privilege over everything, or otherwise manipulating the process to delay or diminish what actually gets disclosed. This is a sophisticated legal move. It anticipates the most likely defense strategy, that some of these documents contain sensitive information about ongoing investigations, third parties, or national security matters, and proposes a structured solution. Rather than fighting over whether documents should be released at all, a special master can review documents individually and make determinations about what can be released, what needs to be redacted, and what, if anything, is legitimately protected. The Hill published an article directly citing the DOJ's handling of the Epstein files and acting AG Todd Blanche's role, which the complaint specifically references in support of the first count. This kind of contemporaneous journalism, woven directly into a legal complaint, is itself a statement about the relationship between press freedom and legal accountability. What makes this case genuinely unprecedented, or at least extremely rare, is the combination of factors at play. You have a journalist suing the government, not under the Freedom of Information Act, but under a specific transparency law passed by Congress. You have a press freedom argument intertwined with a statutory compliance argument. You have a special master request that acknowledges the complexity of the document review process. And you have a plaintiff who is herself a lawyer, which means she understands both the constitutional stakes and the procedural landscape in ways that most plaintiffs in these kinds of cases simply don't. The case is also filed in the District of Columbia Federal Court, which means it will be heard by judges who handle a significant volume of cases involving federal agency conduct and executive power. These judges are experienced with exactly the kinds of arguments being made here. Now, what does this case mean for you? Whether you're a journalist, a citizen, or just someone who cares about how our government operates. First, it's a reminder that transparency laws are only as good as their enforcement. Congress can pass all the legislation it wants, but if the executive branch decides to ignore it and no one challenges that decision in court, the law becomes meaningless. Lawsuits like this one are literally the enforcement mechanism for statutory rights. Second, this case illustrates why press freedom matters in practical, concrete terms. Journalists don't exist just to publish opinions. They exist to gather facts, examine evidence, and present the public with information they need to make informed decisions about their government and their world. When journalists can't access government documents they're legally entitled to, the public loses access to truth. Third, if you're a journalist yourself, or someone who works with sensitive government information, this case is a masterclass in how to use your legal standing strategically. The journalist here didn't just file a FOIA request and complain when it was delayed. She identified a specific statute, built a complaint around multiple legal theories, requested specific judicial remedies, and put her name on a federal lawsuit. That takes courage, it takes legal knowledge, and it takes a clear understanding of what's at stake. If this happened to you, if you were a journalist, a researcher, or a citizen who needed access to government documents that a federal agency was legally required to disclose, and they simply refused, you would have options. You could file under FOIA. You could look for specific statutory authority, like the Epstein Files Transparency Act. You could request emergency relief. You could seek a special master. And you could do all of this publicly, making the government's non-compliance part of the story itself. The law is not just a shield, it's a sword. And sometimes the most powerful thing you can do is pick it up. If you found this breakdown helpful, consider subscribing so you don't miss our coverage of cases like this one as they develop. Federal courts move slowly, but when cases like this reach a decision, the legal and political consequences can be enormous. We'll be watching every step of this one.